Nice to meet everybody. My name is Eric Pacifici. I'm one of the founders of SMB Logger. We are a boutique transactional firm that started operations in May of 2022, so 3 years ago. This May, we're all former big law trained, top 14 educated attorneys that decided to kind of come down market and do the smaller SMB or Main Street, premium Main Street deals. This music is a little hard to, yeah, okay, there we go. Came down market, decided to do the Main Street transactions, fell in love with the space, I assume much like many of you guys, and started kind of networking, and ultimately had a lot of people come to us say, hey, we need a good lawyer for a 2, 4, 6, 8, $10 million deal, who you know, and went out to try to find people for those deals and kind of realized it really doesn't exist. You've got high quality mid-market attorneys that really don't want these small transactions, or you've got Main Street lawyers who will take your deal but aren't really very well equipped to do it. So we launched the firm 3 years ago. In our first full calendar year in 2023, we did about $950 million total enterprise value acquisitions. And so we've done well over $1 billion in closed transactions since then, working across a number of states. Do we have a clicker, David?
Okay, so slides. So I'll press the button for you.
Press the button. Okay, so before we begin, classic disclaimers. I'm an attorney, not your attorney. Consult a good attorney. Everything we talk about today is educational, informational. These are the states we're licensed in. We're actually licensed now in Utah, so that one should be dark blue. But we do transactions pretty much nationally, subject to ethics rules. So depending on what states you guys are in, we can service just about anywhere. Obviously, this is not intended to be marketing or solicitation, but just for background purposes. Yeah, so those are the disclaimers. Wouldn't be a lawyer if I didn't make disclaimers. So we'll go quickly, guys, through standard nuts and bolts on an SMB M&A, Main Street M&A transaction, and then at the end I'll do kind of top 50 most important things that I think you guys should know in the deal, one at a time. We'll see how many we get through. David, how much time do we have?
50 minutes.
50 minutes. So that's a lot of time. Like I said, on any of these topics, guys, feel free to stop me, ask any questions that you have, or we can make it collaborative so I'm not just droning out, because I will drone on if you let me. Fill this line up, David. Okay, so let's start off by talking about the overview of the transaction. What happens? Number one question we get is, how does the process work, Eric? And the high level is, you guys are going to go out, you're going to search for a business. I'm sure you've heard lots of good material about searching for businesses. You're going to talk to Clint Fiore, see what type of businesses he has listed. And then you're going to submit an LOI. So, and this is a little bit out of order, we'll come back to it, but you'll submit an LOI for the transaction, which is kind of your high-level document. You'll match with the bank, you'll do your due diligence, and then you'll work through a purchase agreement in it as well. We'll go through each of these individually, and I'll kind of start clicking through if that works. All right, so what does a lawyer do in your transaction? So number one, we're here to manage legal risk. We do a lot of deals, so we see a lot of transactions. And we get the question a lot like, Eric, should I buy this business? What do you think? And the answer is, guys, you're not going to want to ask your lawyer that question. We are here to help you mitigate risk. We're here to quarterback the deal. We're here to negotiate documents, due diligence, but we're not here to vet the transaction. We're here to work with the other players in the deal. You're going to have a lawyer, the seller's going to have a lawyer, the bank's going to have a lawyer, landlord's going to have a lawyer, franchisor's probably going to have a lawyer. You may have individuals in the transactions, executives, others who have their own lawyers. So we're going to be there to kind of negotiate the transaction on your behalf with those folks. And again, what we don't do, valuation, business risk. Like I said, folks oftentimes, because I think we're one of the only people in the deal that really is incentivized to kind of tell you guys the truth and to not, we're not there just to get your deal closed like your broker is and other people in the transaction are. So we get that question a lot, like, should I buy it? Should I do it? What do you think? And that's not our position. All right, so number one, should you form a search entity? You just started searching, you're looking for a business. Should I form an entity? You can. You can form an entity. It's very low cost to do, a couple $100 in each jurisdiction. It gives you a level of professionalism as well. If you're operating under, Jack Carr LLC or Carr LLC or Carr Ventures, it looks a little bit better and more sophisticated to the broker than if you're doing it individually and signing things in your own name. But you don't have to. The legal risk for not forming an entity is pretty limited. If you sign these NDAs, you're going to sign a lot of NDAs. And if you sign LOIs and don't consummate the deal, there are some legal implications that could come along with that. If you're signing those NDAs and those LOIs in the name of Carr Ventures instead of individually, they can only get access if there is a lawsuit to that shell entity and not to your home and to your personal savings. And so while it is recommended to form an entity while you search, you don't necessarily have to. NDAs. How much should you negotiate NDAs? So again, I'm going to move through these high level and quick, guys. If you want to drill down or visit anything more, we can do that. You're going to sign a lot of NDAs, okay? And Clint, you're in the room. Where's Clint? Did you leave?
You scared him away.
I got rid of that. Is there any other brokers in the room? Anybody who works in these transactions that works with NDAs? No. Okay. Normally we have some in the audience that does. But the point is, you're going to want to read your NDAs. You're going to sign a lot of them. There's going to be a lot of businesses that you look at. Each one's going to have an NDA. You're going to want to read them. Don't spend a ton of time, though, guys, negotiating those NDAs unless it's something really material, okay? If there's a non-compete in there. If you're looking in landscaping and it says in there that if you sign this NDA, you can't work in landscaping outside of this transaction for the next 5 years, you're going to want to cross that out. Anything short of that, guys, you're really going to want to be diplomatic at the NDA stage with a sub. Is there anybody here that's looking for larger kind of mid-market, $10 to $25 million plus transactions? No, everybody's looking for kind of Main Street. With these Main Street deals, guys, the most important thing is to be diplomatic with the sell-side representation. So read them, save them, know what they say, look for big material things. But do not overdo it with the NDA stage because these brokers are going to get, hundreds of inquiries on good businesses. And if you look like a red flag or look like a pain in the ass, they're not even going to read your markup. In many cases, they don't even have legal staff that's sufficient to support the revisions and the back and forth. So they'll put you aside and they'll move on to the next person.
Eric,
Go ahead.
do you have any stories of folks who've actually tried to enforce an NDA? I'm curious if you've seen that in the law set.
We haven't seen any NDA enforcements. That's a pretty, to be honest with you, Samuel, I don't even know if it would be enforceable to say, like, if you tried to put it down, like the big things that I'm worried about, the non-compete, right?
Yeah.
Or a big one is circumventing, if the seller doesn't pay my broker fees, you buy the business, seller doesn't pay my broker fees, you have to pay him on his behalf. I don't think that stuff would be very enforceable. So that's why I say in these transactions, you're signing a legal document, guys. So anytime you sign a legal document, spend time with it, save it, know what it says, look for big picture stuff. But, if you're going to mark it up and actually scratch stuff out, it's probably a waste of time. All right, so legal diligence. So process-wise, guys, again, you're going to sign an LOI. So you find a business you like, you run the numbers, it looks good, you submit that non-binding LOI. We'll come back to LOIs in a few minutes. And then you're going to start legal diligence. And there's 3 buckets of diligence. Bucket number 1 is the business diligence. That's what you guys are going to do. You're going to make sure that the business is something that you can actually run and something that you're familiar with. Bucket number 2 is financial diligence. That's your quality of earnings. By the way, guys, hire a quality earnings provider. We'll talk about that in a few minutes, but don't try to DIY your financial diligence. Number 3 is the legal due diligence. Now, most of these deals, and we'll talk about structuring, are going to be structured as asset deals. Okay, so when you're acquiring assets, have you guys had presentations on the difference between asset, stock? Has that been covered? Yeah, seeing some nodding. Well, and we can talk about it more if you guys want to, but fundamentally, most of these deals are going to be asset deals. You're going to buy the assets of the business, meaning the business is a machine. It's made up of contracts and people and goodwill and all this. You're going to take all that apart and you're going to move it over to a new entity. And when you do that, you sever off 90% of the historical liability associated with the business. So all the dumb stuff the seller has done, or issues, contractual breaches and the like, is left behind in the prior business. So you don't have to diligence the hell out of the business when it's an asset deal. If it's a stock deal, you have to turn over every stone because you're buying the actual business. And so you are inheriting all that historical liability. We can talk about how you allocate the actual potential liability in those businesses. But suffice it to say, you're going to need to do legal diligence no matter what type of structure you have. And you're going to look at all types of things. Contracts to make sure that they're assignable in your structure. How long are they going to exist for? You know, if you're buying a business and one client makes up 50% of the revenue, and that contract is going to, you know, only be in existence for another 6 months, that's a big problem. You're going to want to read those contracts. You're going to want to look for employee stuff. We start out the deal by doing a full what we call it a short form legal due diligence request list, because diligence in these deals is very delicate. You don't want to over diligence the deal. You'll upset the apple cart with the seller. So we have a short form list, but even the short form list, you guys are probably gonna laugh, you know, has 20 categories, everything from the governance to the employees, contracts, suppliers, vendors, everything. So we'll get in the weeds with you guys, and you want to hire a good lawyer to do this, whether it's us or anybody else, to look at all those categories, submit to the seller, you know, all of these questions. And they have an existential crisis when they see the list almost every single time. They're like, what the hell is this? We can't do all this. You can do calls. You can get on calls and walk through things and kind of narrowly tailor it when the time comes. But you're going to have to do legal diligence. Any questions on legal diligence?
So if you're buying the assets, you said you cut off most of that liability, right? So what are you doing when you do the
Yeah, so if you do an asset deal, structurally, 90% of kind of the historical liability, I say 90% because there's a few categories like tax, employment, and employee benefits where you get really aggressive state agencies. If you buy a business with, like, you know, they haven't paid income taxes in a decade, the IRS is probably still going to come after you under the doctrine of successor liability and be able to get at that business. So look really closely if the business involves environmental, employment, or tax issues. And especially if you're in a state like California, Colorado, one that has really aggressive, you know, EPA or employment. But what I'm saying is when you buy assets, 90% of the historical liability, so let's say you've got a default under a contract that's from pre-closing, by the nature of the asset structure, that default or that breach is going to stay with the seller. So the third party will come to you, you bought the business now, and they come to you and they go, Naveen, pre-closing, you guys did X, Y, and Z. Or, you know, back in January, you did X, Y, and Z, and, you know, we're suing you for it. With the asset structure, you get to say, thank you so much for that, but I actually bought the business in March. It is now a completely different business, and so you need to take that lawsuit to the seller, okay? With a stock deal, that's going to be yours. You're going to inherit that. So you want to be careful with your structuring. And we've seen a huge uptick in stock deals because of some changes with SBA requirements that require the stock structure, and it's very dangerous. And we've had a lot of buyers, interestingly, that like a few years ago when we first started, they were like, we love the stock deal because it's so much easier. You know, when you buy the stock, you buy the existing business. You don't have to change the phone numbers and all of the contracts and all this. It's a lot of administrative burden. You know, people buy businesses with asset deals and they're fired up, first time buyer. They're drinking champagne and they think they're going to get in there and be a CEO. And like the next 3 months, you're on hold with Comcast, you know, trying to get them to move the service over. With the stock deal, you don't have to do that because it all stays in place. So we had a lot of buyers when we first started the firm. We're like, we love stock deals. We've done 10 deals and they're all stock deals. And then they come back to us 2 years later and they're like, if we're going to do a stock deal, Eric, you know, we need a 25% discount on the purchase price because that's how much additional risk you take with the stock deal. So structuring in your deal is very important. It does play a role in the legal diligence because they're two fundamentally different transactions. If you buy assets, you are taking the machine apart, right? All the components of it are being transferred over. And so you have to look at all of those components, like the employees, for example. The employees are now being terminated here and rehired here. That's work. The contracts, they have to have if they have anti-assignment provisions in it that say, if you're going to assign this contract, you have to come get the counterparty's permission, you've got to then do that work. And so sometimes, and the question probably obviously logically flowing from this is like, why would you ever do a stock deal based on what I just said, right? The answer is, if taking that machine apart and moving the components over to the new business is too hard or too risky, then you're not going to want to do an asset deal. In fact, an asset deal might not even be viable. Like a really good example is we had a physical therapy clinic, and the buyer was the right guy for this physical therapy clinic, but in order for so about 70% of the revenue of the physical therapy clinic was in payor contracts from Blue Cross Blue Shield. Person hurts their back, they go to Blue Cross Blue Shield, and they say, hey, where do I go? They say, go to Jack's, physical therapy. I'm going to keep using you for sitting in the front row. Go see Jack, right? And then Blue Cross Blue Shield pays Jack. Well, Jack goes to sell that business, and the Blue Cross Blue Shield contract that's driving all the revenue says, if you're going to sell the business and assign the contract, you got to go get Blue Cross Blue Shield's approval. Well, the existing seller goes, we're not doing that. We're absolutely not doing that, because if we do, and if we ask Blue Cross Blue Shield, number one, they're almost certainly going to say no. But number two, it just injects way too much risk into my business. So your options, Naveen, are to buy the business as an asset deal and take that risk and go talk to Blue Cross Blue Shield after closing, or buy it as a stock deal. So in that instance, you would obviously buy that business as a stock deal. Does that make sense?
Yeah.
Yeah. Anybody have questions on the difference between assets and stock based on what I said?
What you had said earlier about, let's say there's a pre-existing breach of contract issue from before you transfer the assets over. That doesn't follow the assets, but what if that's been disclosed in the due diligence? What if you're aware of that? Is that transferred in and with the assignment of those contracts or rights related to those things?
That's a good question, right? And that gets into the contract negotiation, because that's going to be your risk allocation, and you're right. So to go very high level, in just a minute, we'll talk about indemnification, and I'll jump to it because I think this ties up nicely. Structuring the deals that we just talked about, purchase agreement overview, the reps and warranties, indemnification. So the diligence that you guys are going to do, guys, no matter how much time you spend looking at the business, you can go nuts. You're not going to find everything, and you shouldn't try. If you try to do that, you're going to drive the seller crazy. You're probably going to lose the deal. So how do you make up for that as a buyer? Reps and warranties and indemnification. Reps and warranties are a number of statements that the seller is going to make about the condition of their business at the time of sale. Everything from it's properly formed, they actually own it, they have authority to sell it, here is our capitalization, the contracts, there's no breaches under the contracts, employees, environmental, tax, brokers, everything that's really important in that contract. This is where you guys will run into trouble if you utilize like some of the templatized stuff that's on the internet, like, oh, I'm just going to do this for cheap. You're going to lose the benefit of this, right? This is going to be the only thing, if you hear anything I say, hear this. This is going to be the only thing that's going to save you guys if after closing there's a problem, right? You show up, you buy the business, and the trucks, that were supposed to be working are not even street legal. These are real examples. You show up and the employees go, yeah, so glad you're here, Jack. The seller, he said you were going to fix all these trucks when you get here, so let's get them fixed. And you're like, what the fuck? Now I have an additional $100,000 in trucks I've got to buy. You turn to the reps and warranties. You turn to the rep on the assets, that the assets are in good working order, that they're sufficient for the purposes of the business. So that's a really important point in the negotiation, right? Because what the seller is going to try to do is they're going to try to carve out all of these issues, right? They're going to know the trucks are a problem. So if they've got good counsel and if they're honest and they're prepared, they're going to go to that sufficiency of assets rep, and they're going to go, no, we're not repping that the assets are in good working order. You're taking them as is, where is. And also, I'm not going to say that the assets are sufficient for the purposes of running the business, because that's too loosey-goosey, and you could argue that we needed a forklift and we didn't have one, so you're going to buy a forklift and I'm going to have to pay for it after closing. You have that negotiation. Now, we're prepared for all of those talking points and we've done all of that, but that's exactly right. they're going to try to schedule all of the breaches of the reps in advance. And if they tell you in the process and they schedule and they say, Jack, in that schedule, these trucks are, all of our assets are in good working order except for these trucks, then after closing, you cannot bring an indemnification claim or a breach claim against them for those trucks. Does that make sense? So this is the most important part of the negotiation because, again, this is really the only thing that's going to save you guys after closing. Now, what is indemnification? Indemnification is a contractual dispute resolution mechanism. So in the absence of this, you did not have indemnity and predetermined outcomes for disputes. If there are issues, you're going to actually have to go to court and you're going to have to prove up those disputes. Very expensive, hire lawyers, big, administrative burden. Nobody wants that. So you hardwire into the contract an indemnification provision that spells out what's going to happen when you show up and the rep says that the assets are sufficient for purposes of the business and the trucks are crap. What happens? You run those rep breaches through the indemnity mechanism, and then you follow the path to get your money, right? Because even if the reps are tight and it says that the trucks are great, you show up and they're not, and yep, I've got to breach of the contract. You then have to get money, right, from the seller, and that's not easy. Seller takes the purchase price, they pay off their mortgage, they're on a catamaran in the middle of the ocean. How do you actually get the money, right? So you've got a great contract, but it's not worth the paper that's printed on. The indemnity is going to give you a predetermined pathway for recovering for those breaches. And the best way, or the most common way in these deals, is to have a promissory note. So you guys will have a promissory note. Some portion of the purchase price should actually be in the form of a promissory note to be paid over the coming years. And you'll set off against that note. So you'll say, hey, the trucks were $100,000. We had to have them inspected. There was that cost. Then we had to have them fixed. There was that cost. Also, I had to go hire a lawyer. I had to come back to Eric and say, hey, you breached this rep, and he sent a bunch of demand letters, and you guys bought. His legal fees were, $1,000. All of those costs then are written down against the note.
You're holding them into the transaction.
Exactly. Yeah, and if anybody here is familiar with mid-market M&A or larger scale M&A transactions, you oftentimes have a indemnity escrow. So you actually take a portion of the purchase price, set that aside, and you recover against that. That's not very well accepted in Main Street M&A. Everybody's going to want, all of the sellers are going to demand that it's done against a promissory note, not in cash, almost all. So really important that you guys have a promissory note in your deal. That's one of the 50 things that I'll go through in just a minute. But any questions on indemnification, reps, warranties? Yeah, go ahead, Sam.
The trucks example is a really wonderful example of a fundamental representation that someone would breach. I don't know if you've had any other examples you can share with us that just come to mind.
Yeah, we have every example under the sun, right? And it's not just reps, actually. Let me clarify. It extends to pretty much everything under the contract, including your covenants, right? And the biggest covenant, what is a covenant? A covenant is a promise to do something or to not do something. And so your non-compete is the most prominent covenant in your purchase agreement. If they compete with you post-closing, you turn to indemnification. But, what are some examples that we can give from real deals? Obviously competing is a big one. A really big one that actually turned into a lawsuit that we won was they made off with the seller had a Amazon seller account. It was a $10 million purchase price. And it was a B2B sales business of a certain type of product. Well, the product was being sold primarily through Amazon. And the Amazon account had 4,500 five-star reviews. It was enormously important to the business. Without this Amazon account, the business is almost going to fail. But it was in the seller's personal name. And he was like, Samil, I tried to talk to some Amazon consultants on Amazon. I gave it to, gave it the old college try, and I can't transition it to the business, and so I'm just going to shut it off, turning it off.
Oh.
And we were like, dude, you cannot do that. And also, if you do, we purchased that Amazon account. Because again, in the asset deal, backing way up, when you buy the assets of a business, you're buying everything, right? Your contract should say, if your contract doesn't say you're getting all of the assets of the business except for what's explicitly carved out, you've got a bad contract. You don't want to have to list all the assets of a business, and this is a trap for the unwary. Sellers counsel will try this on you guys. They'll go, hey, like we're just going to itemize in a schedule what you're buying. Well, the problem is, guys, like you don't know this business at all. They've been running this business for years. Last thing you want is to have to try to go through the factory or look at all the machines and figure out what you need and what you don't need. You're getting everything except for what they tell you you're not getting. Okay, so in our Amazon seller account situation, our contract said we are getting everything related to the business, whether it's held by the business, used for the business, in the name of the business, not in the name of the business, now existing, not existing, intangible, tangible, very, very thorough. Well, the seller's lawyer, he's an old boomer guy. He's like, Eric, I've never seen a contract where the assets held by the individual or purchased assets. I'm like, well, you're wrong. I'm going to just read the language. It says it right here. We went back and forth 3 times. Finally went to court over it and won. But you want to be very broad to make sure you're sweeping all that in. So that was a big one. And that touched many different parts of the contract. The assets that we purchased, a covenant that they have to make that they're going to take steps. It's called further assurances. It is a covenant that they say that when they sell you the business, if there's any of the components of the machine that won't transfer, for some reason, then they're going to continue to do what they need to do, no matter what it is, to make sure that you get the benefit of those assets. Okay, and if they can't, like in the situation with the Amazon seller account, they'll create an economically feasible relationship to support those assets. So in this instance, there was an Amazon consultant and all this, and he's like, oh, I tried twice, it didn't work. Well, I'm like, dude, the contract says you got to keep going, and even if you can't, you got to facilitate that. He's like, I'm not going to do it. So it touched on the reps, it touched on the covenants, it touched on the assets that we purchased, and a bunch of things in there. That's probably the most prominent example, but there's all kinds of stuff with the non-compete, carve-outs to the non-compete. It says you can, run fire safety, Sean, get.
There's a quick question, and want to cut off your thought. I think one new thing that at least I discovered this morning was this concept of rep and warranties insurance at this LMN level. Just first principles, not something I've seen a lot personally. Interested what you think about it and how it might apply for the search.
Yeah, I mean, the practical answer is we haven't seen a rep and warranty insurance product. What is rep and warranty insurance? And Sean's question was, how do we feel about rep and warranty insurance for small business M&A? Pointing at somebody. Rep and warranty insurance is a very popular mid-market product. So you buy a business and there's a rep breach, the trucks are crap. Instead of recovering against the seller, you recover against an insurance policy. So now you got an insurance company in there backstopping it. Everybody loves it. Most everybody loves it because we're recovering against an insurance company. Seller loves it because they get to walk away. And so it's a nice product. We haven't found yet a good analog in small business M&A that's been widely used. A CFC, who's here, which full disclosure, they actually gave me these socks. So I feel like I feel like I have to disclose it ethically. Yeah, it's really rare. Like, there's not a good product. They're like, well, it's CFC's. They're developing a product. They have had a sell side product. They now have a buy side product. Is there somebody from CFC here, by the way?
Yes.
What's up? You want to just give us 30-second blurb about your product and how it works?
Yeah, sure. So I've got a bit of a cold, so should you know the mic? Is there a mic?
Yeah. Want to run him a mic?
There we go. Yeah, so we've had a sales cycle product for the last kind of 2 to 3 years. Sorry. And as Eric said, we've just got a buy-side product out as well. Both the products are kind of specifically developed for the SMB segment of the market. So anything below about $20 million, so it should be pretty suitable for everyone here. If you want to discuss it in a bit more detail, we've got a table out there. We've got loads of brochures, information on that kind of thing. So yeah, happy to chat.
Yeah, thank you for that. And you're to be clear, you're the only product that I'm aware of. We've got some insurance people. The new code risk guys are here. I don't know if they're familiar. Just to be full disclosure, I don't know if there's any other products in the marketplace, but I've worked on one deal where CFC placed the product a couple years ago. It was a nightmare of a deal. I had a tax lawyer on the Burt Wolf. Shout out to Burt Wolf at Nashville. It's the biggest fucking nightmare in the world. But we placed your product in the deal. So I should check back with that buyer and see if there's been any claims. But so, guys, reps and warranties, indemnification. This is why you hire a good lawyer, right? Because every single time, and I'll get to you in just a second, post-closing, if I get a call from a buyer, and we often do, and they go, hey, we got XYZ issues. We got one in Seattle right now in a landscaping deal, and he's got a bunch of equipment and stuff. He's got receipts that he's arguing with the seller. You call me up and you say, hey, I got this problem. I'm going right to your purchase agreement. I'm going right to your reps. I'm taking the facts that you're giving me, and I'm seeing if we've got a rep to cover it. And if you don't, you're out of luck. So this is the value of hiring a good lawyer, doing the diligence to make sure that diligence flows into the reps, and that the reps flows into an indemnity provision that will support a recovery. There is some mass, and I'm a big believer in AI and utilizing kind of some of the new AI tools. We use them a lot in our firm, but there are some mass-produced document companies. There's one in particular that has, buy-side templates, and they're selling the package now. It was $6,000 now. I just refreshed the page today. They upped it to $8,000. People are giving these guys $8,000. Their templates don't have survival for their reps post-closing. Okay, we can talk about what this means in detail, but their reps don't survive closing. So you got all these great reps. You got trucks that are broken down, but those reps don't survive closing. So you come back a month after closing and go, hey, I just discovered the trucks are crap. Well, guess what? Your reps expired at the time of closing. They should survive for 12 to 24 months at least for kind of the lower priority ones. And for statute of limitations are basically forever for the higher priority ones. And so be very careful with this stuff, because again, this is the only stuff that's going to save you. And one of the tricks that you can employ, because we are opposite in most of our deals of people who don't know M&A at all, is there's a well-worn path in the market for what reps should survive and how terms should play out. Well, again, going all the way back to the very beginning and saying that most of the lawyers that are in this space are these Main Street guys that really don't know M&A at all. You guys can get really absurd terms. We have clients, and I'll do this for you. I don't like to be predatory or aggressive, but in this one area, okay, you can get really favorable terms if seller's counsel doesn't know what they're doing. So we have to go in there, delicately hold their hand and kind of get the transaction across the finish line, which is more difficult, but in terms of terms, you guys are going to get more favorable terms. So one example is with ordinary reps. So typically the sufficiency of assets rep would be a ordinary rep. You can try to turn that into a fundamental rep. So instead of it surviving for 12 to 24 months, it survives for 5 years, or for statute of limitations. So if you're discovering stuff, 3 years later, you could still theoretically recover, whereas you would otherwise be contractually barred. And this is really important when it comes to these stock deals. Okay, again, back to structuring. When you buy the stock and you buy the whole business and not just the assets, there's all kinds of stuff. Like a good example right now, we got a roofing business that we're doing. There's a 10-year statute of repose and a 5-year automatic warranty in the state of Florida on roofing work. When you buy it in a stock deal, all that warranty stuff is yours, okay, for a full 5 to 10 years. That's not good, okay? So if you have the extended reps, better indemnity in that stock deal, you could have coverage for that stuff 3, 4, 5, 6 years down the line. Whereas if you bought assets, obviously you settle it off right away, but that's where it really comes into play. I'll pause there. This is the most important thing we're going to cover. So any questions? Go ahead.
So reps is representations.
Reps is representation. So representation is the way something exists in the moment. A warranty is about the future, but that's a distinction really without a beat. It just basically means you're going to make statements about this. Yeah.
And so I don't have clarity yet what my niche is, so I imagine that drives the answer to my question, which is how do you know what foot to get off of, asset or stock base?
So always default to asset, guys. So it was, the marketplace was 90-10. The assumption was asset deals, throughout the entire marketplace. Well, 2 years ago, the SBA changed the rules on partial rollovers. They said, okay, instead of, up until I think it was late 2023, if you were going to buy a business, you had to buy 100% of that business, and the seller had to leave. They could walk away. Or they could consult for 12 months, but they couldn't do an employment relationship if they needed to get completely out of the business. The SBA changed that. They said you could now buy less than 100% of the business, but in order to do that, it has to be done as a stock deal. I don't know why that was the distinction, but that was because, again, you got bureaucrats making rules that don't know, the reality of the ground. But we saw an explosion in stock deals because people got super excited. And I got really nervous about that, right? Now we went from 90-10 or 95-5 to 60-40. Okay, tons of stock deals. So right now in the marketplace, there's a lot more stock deals waiting to have issues. So that's not good. But they ultimately have now changed those rules. So now you can do the rollover as an asset deal. But you still, you want to make sure. And what you'll find, your question was, when do you do a stock deal versus an asset deal? Default to the asset deal in your LOI. You can include some language that says, if we discover reasons or whatever, then we'll flip to a stock deal. Oftentimes brokers will tell you up front if the business has conditions that make it necessary for a stock deal, like those Blue Cross Blue Shield payer contracts we talked about, or if the seller is going to demand it for tax purposes. Oftentimes the seller is going to require a stock deal because of double taxation with a C corporation, or the biggest reason is qualified small business stock. If you guys are familiar with QSBS, if you're not, Google QSBS after this and we could talk about that. Really powerful tax strategy for clearing up to $10 million in capital gains. But in order to do that, if you started a business, you've held it for over 5 years, and you want to exit, sell your business for $7 million and not pay any capital gains, under the qualified small business stock rules, you have to sell it as a stock deal. So the broker should tell you on day one, hey, this is going to have to be a stock deal, and if it's not a stock deal, they're not selling to you or selling at all. So that's it for that.
And are you finding discounts on those deals? If I'm a buyer, like the seller wants the QSBS deal, stock only, I'm like, well, I'll pay less. Are you noticing that, or?
You're not finding discounts, right? Really tough to find a discounted high quality business in the marketplace unless you find it off market, and we can talk about off market deals, very risky. But you can do some tax strategy stuff. So when you buy assets of a business in an asset deal, you get what's called a stepped up basis in the assets of the business. So you take the purchase price, you apply it across the assets. And we can get into the weeds of what I'm saying, but suffice to say it's better for tax purposes with an asset deal versus a stock deal. With a stock deal, you inherit the historical depreciation and amortization schedules, not as favorable. But what you can do is you can make an election in a stock deal to have your deal treated as an asset deal. It's called the 338H10 or F reorganization. So you take the stock deal and you convert it for tax purposes to asset deal. And that should be market, but that has to be in your LOI. You have to tell them that up front. And one of the practical tips I have for all you guys is make sure the seller appreciates their tax considerations or their tax outcomes early in the deal. We see way too many deals where it's like we've been in process for 100 days, we're 15 days pre-closing, the seller talks to their CPA, and their $6.5 million purchase price is actually now 3.7 plus a broker commission, and they're like, wait a second, I'm selling a business for $6.5 million and I'm only walking with 2.7. Shit, I don't even know if I want to do this anymore. So make sure that they appreciate that stuff very early on.
Yeah, I wanted to ask for the C corp. If you're buying a C corp, how do you structure it so you get the QSBS advantage? Because you have to issue new stuff.
Yeah, so QSBS, we can talk about what the nuts and bolts of that are, but QSBS, I gave a presentation yesterday at the Holdco conference, and half the time was just questions on QSBS, so it's a very popular topic. But it has to be original issuance. So you start a C corporation, you issue stock, you start a 5-year timer. It only qualifies for certain types of businesses. But it has to be issued on day one. So if you buy and you want to talk to a tax attorney or a good CPA like Adam Webster, who's here, is amazing from Hollywell. You want to talk to those guys, but I suspect you need to, and Adam, feel free to jump in. I suspect you need to move the business out of that existing C corporation into a new one, or you're not going to have QSBS, right?
Yeah, my understanding, so I'm not a M&A
Oh,
tax
sorry.
guy, but my understanding from speaking with M&A tax folks is that there's ways to do it, but it has to be specifically and intentionally structured at the time of your acquisition.
Good question.
I know we're still pressure testing it, but on the issue of the seller understanding kind of like their walkaway proceeds, you want to touch on deferred sales trust a little bit, kind of like what we're exploring a little bit.
Yeah, Sean brought me this cockamamie idea the other day, so maybe you want to tell me about it. You introduced me to the sales guy and the whole deal.
Yeah. Okay, so it sounds too good to be true, but and I'm still pressure testing, but evidently it's been audited, 50 times between the IRS at the federal level, 30 times in California. But the idea is that when you are selling your business, you first sell it to an inspected grantor trust. And then that grantor trust takes ownership of the business, and then you purchase the business either in an asset or stock sale from the trust. And then the proceeds from the purchase go to the trust vehicle, and then only when, as and if, those proceeds are withdrawn from the trust and distributed to the seller, that's when they pay taxes on it. So sounds way too good to be true. I brought it to Eric. By the way, I'm the newest member of SMB Law Group, so just bringing in all sorts of problems. But I think good problems, champagne problems, to deal with. But I think I use it in my LOIs for the businesses that I'm acquiring because I think it's something that's powerful and distinctive, and something I hope that we can use both for our buyers when they're buying and also our buyers when they're liquidating on their assets.
Yeah, but I think the upshot is anytime you can help the seller tax-wise, or you can help them appreciate the tax implications of the deal, that's a good way to make sure your deal's going to close and they're going to be happy with you. Especially if they're rolling equity. Anytime you roll equity and they're going to be now your partner, and that's my second concern of the equity rollover is like now you're partnering with somebody that may not be a good partnership. Make sure they understand all of the implications before you get into a marriage on a bad foundation. Go ahead.
This is only if it's a C corp though. Like if you're going to potentially buy an LLC, you need to potentially prep them for like QSBS situation.
So it has to be a C corporation to qualify for QSBS. If you're buying an LLC, there would definitely not be QSBS eligible unless they made a C corp election, which is conceivable, but probably highly unlikely. But yeah, it'd have to be a C corp.
So how do you ethically early on test that, get that going in their mind without actually pushing them into it, and then you use your asset-based deal structure?
Well, so you ink an LOI that says it's going to be an asset deal, and then you encourage them to understand the implications of it early, right? My goal, if I were to buy a business tomorrow, I would want the seller to, I would tell the seller diplomatically or the broker, I would say make sure they are having a conversation with their CPA before I put down a deposit with the lender for a lender commitment, before I am doing, $25,000 worth of QOB, before I'm, investing meaningful money into legal. Like I want to know that they've had those conversations and understand what the bottom line is going to be early on in the transaction. I would backdoor that through the broker.
Quick question. I know we're mostly talking about kind of seller-facing legal issues, but on the lender side, you take a seller note. You also take bank debt. So you've got, I assume there's an intercreditor or a subordination agreement between the two, typically. Let's say there are no indemnity claims, so you're just paying off the note. Have you ever seen issues either on bank side or on seller side, kind of getting the aligning terms in terms of subordinating that seller debt to the bank debt? And I assume they don't care about offsets because that's no cash out the door. It's just a straight offset. But if it's a shorter note, a 3-year or 4-year note with the seller, do the banks ever have issues, or is that usually pretty smooth?
Well, so when you underwrite your deal up front, the bank's going to tell you from a cash flow perspective what you need in promissory note terms. And the question was, what's the interplay between the seller debt and the bank debt? Okay, it's a great question. And there does have to be a subordination of the seller debt to the bank debt. Okay, and that's going to really take the teeth out of the seller debt in a very meaningful way. There's a standard SBA subordination agreement. You're probably thinking, oh, that sounds like an awkward conversation to have with the seller. Well, it's not, right? Because the vast majority of these businesses are not going to sell unless they sell with SBA debt. SBA creates the liquidity for the whole marketplace. So oftentimes you get into points in the transaction, and what I try to say diplomatically is like, listen, dude, like, I know you don't like the idea of subordinating your debt to the SBA. This is not a Jack Carr problem. This is a problem with your business. If it was bigger and a buyer could get conventional debt to buy this business, then you might have negotiating leverage. But this is just the way it's going to be. Whether you sell it to Jack or you sell it to anybody else in this room, you're going to have to subordinate that debt. And then the only time the bank cares, the SBA lender cares about offsetting against that note is if the note is used for equity injection purposes. So with an SBA note, you have to put down 10%. Everybody knows that. You can reduce it to 5% if the seller does what's called a standby note. So they'll put 5% of the purchase price into a note that is deferred for either 24 months or 10 years. And if they do that, and if the bank qualifies that for equity injection purposes, there are some institutions that will say that you cannot offset against that equity injection specific note. That's a big trap for the unwary. You hire a lawyer who doesn't know this, you'll get very deep into the deal thinking you're going to have an offset against that note. And then the bank will tell you at the 3-yard line when they finally bring their lawyer in that actually, no, you cannot offset against that note. Now you got to go back to the seller to either renegotiate to get a means to recover on your claims or have no means to recover at all. So it's just a very bad situation.
Let's do one more question, final question, and then we gotta get rolling as much. But
Quick question on the warranty thing that you mentioned earlier. So if you're doing an asset deal, the customers don't get the warranty on the roof, right? So are they just SOL basically if the business is sold?
Well, they still can recover against the seller, but the seller's probably emptied out that entity that sold the assets if they're smart, and so the recovery would be against the shell company. And the answer is, yeah. I mean, that sucks. That's if you guys have any type of agreement with the business and it goes bankrupt or whatever, then you're out of luck. And I would imagine it's not that simple, right? There's going to be state statutes that govern the 10-year repose and I talked about doctrine of successor liability, so that's why I said 90% of the time it's going to sever it. That 10% is the law saying, hey, even though there was that line in the sand, like we don't care because we care so much about environmental, or I'm Uncle Sam and I don't give a flat fuck about your deal structure, you owe me that tax money, and then you got to figure it out.
cool. All right, everybody, thank you, Eric, for coming along and sharing that.